Members, we have a quorum. Right? So let's call to order this meeting. After the last meeting, we received from the Hong Kong Bar Association a submission stating its views, and the administration has responded to the Hong Kong BA's views. So this meeting will mainly deal with the Hong Kong Bar Association submissions and the administration's response issues raised by the Hong Kong BA, and that CSAs have been proposed in response to those issues. And we have from the administration Mr. Paul Wong, Principal Assistant Secretary for Financial Services and Treasury, Ms. Teresa Wong, Official Receiver, Ms. Fiona Lee, Assistant Official Receiver, and Mr. Alan Chong, Senior Government Counsel from the Department of Justice. So, welcome to the meeting. May I invite the PAS to walk us through the administration's response to the Hong Kong BA's submission. And there are a number of letters which you should have. CB bracket 11229/1415 bracket 011293 and CB 1134. I think the government's position is quite clear. So PAS, over to you. Thank you, Chairman. Thank you, members. In September and October, on 2 occasions, we received submissions from the Hong Kong Bar Association. The administration has prepared our response to the issues raised set out in the papers mentioned by Chairman. So just some opening remarks before I walk members through the papers. On the objective of the bill and latest developments, I have the following remarks to make. I want to emphasize that the objective of the bill is to replace the existing abscondee regime. This is one of the major pillars in the bankruptcy regime. And a bankrupt will automatically be discharged from bankruptcy upon expiry of the 4-year period. And we have introduced 2 mechanisms. That is, before the bankrupt is discharged, if the bankrupt is uncooperative with the TIB, trustee in bankruptcy, then there is an objection mechanism for the TIB to apply to the court to suspend the period. And the other mechanism is the non-commencement of the period. So we have both mechanisms in our regulatory framework. And earlier, the Court of Appeal pointed out in a case and ruled in relation to one of the sections, the official receiver has imposed an unnecessary restrictions on the right to travel. So when we come to our discussion of the issues, we may go through the technical details. But I think I need to reiterate the objective of the bill. So we would like to encourage cooperation between the bankrupt and the trustee in bankruptcy, TIB, by providing information to the TIB under the bankruptcy regime. This is the objective. As for the sanctions, it is not our objective to punish the bankrupt, but rather to encourage cooperation with the TIB. And as for the latest developments, last Thursday, the Court of Final Appeal, in relation to the abscondee regime, in relation to Section 30A10B1, which was earlier ruled as unconstitutional, And the Hong Kong Bar Association also mentioned for the transitional provisions, as we were unclear what the CFA ruling would be, we have introduced transitional provisions to deal with the different scenarios. But since the position has become clear, I will walk members through the changes to the transitional arrangements. So let's start with our response to the Hong Kong BA's submission. One of the Hong Kong BA's concern is whether physical presence is required during the initial interview, or whether the interview can be held by other means such as video conferencing. And our position is that physical presence is required because we need the bankrupt's physical presence to go through some procedures. For example, to check the bankrupt's identity document. They have no objection to the policy objective, but the association would like us to to expressly provide for this point, and therefore the CSA has been proposed to make it clear that physical presence is required. Maybe the DOJ colleague can walk members through that in a moment. In short, there will be another provision to define what failure to attend the initial interview is. That is, the bankrupt has failed to be physically present at the initial interview, so as to make it clear to readers. We believe that this can provide greater clarity. So we don't think we need to expressly provide a definition for the meaning of initial interview as suggested by the Hong Kong BA. I believe the same objective can be achieved using our approach. The second issue raised by the Hong Kong BA is this. If the TIB is to apply for a non-commencement order, then in the application the TIB must inform the court of the steps taken to notify the bankrupt of the initial interview. And the suggestion is to provide some guidelines on what is meant by reasonable steps to notify the bankrupt of the initial interview. However, each case differs on their own circumstances, and therefore we would require under Section 89 that the TIB would need to give an account of the steps taken to notify the bankrupt of the initial interview, and the court will have the discretion to make a factual ruling. We believe that this is a more flexible arrangement. If we provide expressly that, say, 3 steps must be taken for the notification to be deemed successful, then more disputes may arise from 3 steps, and on how to or on what is meant by completing the 3 steps, for example, more controversies may arise. Let's say if we provide that the TIB should make 10 phone calls, and there will be disputes on what is meant by 10 successful phone calls and how many seconds must the phone ring. So I think the simplest way is for the court to decide the matter based on the facts of the case. We believe that this our proposal will strike a balance. The third concern of the Hong Kong BA is this: whether the TIB can adjourn the initial interview and request the bankrupt to provide information at the next interview, and failure to provide information or attend the next initial interview, there is a question on whether the bankrupt will be subject to any penalty. And the objective is very clear, that it should be a one-off meeting as far as the initial interview is concerned, and it is very critical to the rights of the bankrupt. We need to make it clear, and we've explained very clearly in our policy objective that it should be a one-off meeting. And we've explained this in our response as well. Of course, it's possible that there may be subsequent interviews, but the subsequent interviews will not be caught under the initial interview arrangement. And of course, in subsequent interviews, the conduct of the bankrupt may affect the TIB's decision to extend the relevant period, say, for example, if the bankrupt is uncooperative. Fourth concern of the Hong Kong BA is this. Now, some TIB may be late in applying for a non-commencement order, and the delay may not have been caused by the non-cooperation of the bankrupt, but rather the responsibility of the TIB. And there is a question on whether the court will order the non-commencement order from the first date of the relevant period. We discussed and we explained to the Hong Kong BA, and as I said in my opening remarks, in the whole mechanism we have, in the whole regime, we have two mechanisms to encourage cooperation of the bankrupt with the TIB. Now, if the bankrupt fails to provide information or fails to attend the initial interview such that the TIB's work cannot commence, then the whole period should be regarded as not having commenced, because the TIB's work cannot begin, and if there is prejudice, then should the TIB or the bankrupt share a larger portion of responsibility, and this will be decided by the court on the merits of this case. And if the court is of the view that the the bankrupt is not responsible, the court then can reject the TIB's application. Finally, on transitional arrangements, as I explained just now, the Court of Final Appeal already ruled that the 30A 10A is unconstitutional. We are going to propose an amendment to repeal 30 capital A 10 small letter a, so that the transitional arrangements would be clear to everybody. That is, only 30A 10B2 is still in operation, and this provision will be preserved.
Thank you. Dennis Kwok, thank you, the administration, for explaining to us. First of all, I'd like to ask about the initial interview. The latest wording, what would it consist of? How precise would it be? Could you explain? I think for the clause, we will actually lay down we'll move a CSA, on that. And the Bar Association has said that besides the face-to-face initial interview, if after the initial interview there needs a need for a subsequent interview, then would the new CSA accommodate that as well? I think for face-to-face interview, later on I can ask my colleague from DTFJ to tell you about the wording to be used. And Mr. Kwok also, well, as I told Mr. Kwok, we will give you a CSA paper later on. And also, on your second question, for the first or initial interview will be a one-off interview. Of course, the trustee would need to understand the regime to be able to ask the questions they need to ask on the first occasion. There may be subsequent questions that he wants to ask. So there could be a chance for second or third interviews, but that will not make up the part of the initial interview. So in a reply, we've made it clear that there could be the second or third interviews, but they would not be regarded as the initial interview. And all the sanctions related to the initial interview would not be applied to the following interviews. If there were to be third, second, or fourth interview, that would be a great uncertainty to the bankrupt, because he would know under what circumstance there will be, the third or the fourth interviews or more interviews during the 4-year period, and whether it be bound by the sanctions. So as I explained on various occasions, it will be a one-off interview, and the following interviews will not be bound by the initial interview. So I think that's clear. If the bankrupt attends the initial interview and yet he is non-cooperative and failed to provide any documents or information, then is that the trustee can, should that happen, invoke the clauses to bring about sanction? Yes, because the bill now stipulates under what circumstances can the trustee take action. First is the bankrupt fails to cooperate or does not attend the interview in person. Okay, last question. Would you reconsider the suspension order? I understand. Yeah, in response to the Bar Association's point. Yes, as I tried to explain just then, we do intend that, we feel that if there is to be a sanction, it should be counted from the first day when a non-commencement order or the bankruptcy order takes effect. Okay. Okay, GFJ. Yes, thank you. Mr. Kwok asked about, having to be present in person at the initial interview. We have actually come up with a written provision on that, but still we need to discuss that with the legal advisor to LegCo first. And so far we've only got the English version. Maybe I'll read out the English version first. Under 30AB, we will insert a new clause which states so in Chinese it states that should the bankrupt cannot attend the initial interview in person, then he'll be seen as, under clause 1B, be seen as not having attended the initial interview. Okay, we'll wait for your formal provision when it's ready then, and the legal advisor will look at it before we begin the scrutiny of the clause. Okay, members, any other questions? Legal advisor? The administration has also given us a response to our legal advisor's points raised. Okay, so the administration, yes, in response to the Bar Association's proposals, and on the administration's response, the Legal Affairs Division has made some observations. Firstly, on the definition of initial interview, we agree that right now, under the existing bill, there's room for the readers to doubt whether the interview needs to be attended in person and whether it would include subsequent interviews. As you heard from the administration, we will make a consequential amendment on that. And since the administration this time hopes that it would include the clause or insert a clause on being physically present for the interview. So for some bankrupts, like as what the Court of Final Appeal on 30A bracket 10 small letter A, on its ruling, if the bankrupt is not in Hong Kong, and under the current regime, since there's this element of physical interview, so whether we need to ask the bankrupt to come back to take part in the interview, if that's the case, should the bankrupt be able to come up with reasonable explanations or justifications, then, and if the bankrupt is willing to cooperate, then under the current bill, whether like before, as long as the bankrupt is not here, we can apply for a non-commencement order. Assistant Secretary, yes, thank you, Legal Advisor, for your query. I think, as I said in the beginning, under the current regime, the difference now is before, in the system or regime you referred to, if you are not present, then the non-commencement will take effect automatically. But now there will be a need to apply for that and also to get approval from the court. And the other difference is if you have reasons that make you unable to come to the interview, say for example, as I said, if I came back to Hong Kong and there was a major traffic disruption outside the airport, then I couldn't come to the interview in time. But under the current regime, it's not that not being able to be present for the interview is not a reason for the application. It's not that you must make it. You need to look at in the application form in the court. You need to prove to the court that there's prejudice caused. As legal advisor said, if the bankrupt can take some remedial action, or if he can provide sufficient information later on, that could affect the outcome. That's why we have to leave it to the trustees to make the judgment and also the court to exercise whatever discretion it wants to exercise. So we have to look at whether all the information documents have been collected and whether the bankrupt can prove to the court that the prejudice has been caused. So there's room for the court to exercise discretion. And that's in line with the concern raised by the Court of Final Appeal on the automatic, validity, because the automatic validity of the order will be too much of a restriction on the bankrupt. So even if the bankrupt cannot attend the interview in person, there are other conditions that need to be met. That is, the trustee needs to be able to prove that prejudice will be caused to the administration of the estate, and also the justification should also be provided for why the order should not be issued. Thank you. On the Secretary's response, because the new regime is to replace the previous abscondee regime, under which, because that regime was challenged in court. And the latest design, well, despite what you said, under the current bill, there's also the element of asking bankrupt who are away from Hong Kong to come back for the interview. That's what you just said, right? And this element, plus the non-commencement order, I think you do need to explain to the committee that is under the current design of the regime whether it would not cause an infringement of the bankrupt's freedom to travel and get out and back into Hong Kong. Yes, of course, when we before we submitted the bill, we had shown our drafts to human rights lawyers, and they've affirmed that our current design is in line with the CFA's requirement and in line with its concerns about the previous legal provisions. For those who are away from Hong Kong, we would expect them to come back for initial interview. Yet, a difference with the previous abscondee regime, once you cannot make it for the interview, the delay in implementing bankruptcy would take effect automatically. But now, under the latest design, a number of conditions have to be met first, whether prejudice has been caused. That would be a consideration. Okay, members, any other questions? No? So when will the administration submit to us the CSA? In a week's time. In a week's time, okay. In a week's time, then members have no other questions. Then last time we did the clause-by-clause scrutiny. Let me tell you about the timetable then. Administration, do you have any time for a second reading? Any time in mind? The earliest time is December 9. The other date is December 16. I think December 16 is more appropriate. Let me discuss with the Secretariat. Okay, if you have December 16 in mind, then second reading, resume second reading debate. For that, we need to issue a report to House Committee on December 4th.
Huh?
So to report to the House Committee on the 4th of December. And then notice to resume second reading would be the 7th of December, a week before. And then on the 16th of December, we'll resume second reading of the bill. I understand that there are no CSAs from members, but there will be CSAs from the CSA, from the administration. So please submit the CSAs in a week. Any other questions from members? No? Then that's the end of our work on the bill. I believe that after the administration has submitted its CSAs, the legal advisor will help us read through them. I don't think we need to call for another meeting. The legal advisor will be in contact with the Secretariat and will deal with the issues before the deadline. Any other views? No? So meeting's adjourned. Thank you.